Welcome back to Government Information Gathering with Mike to Bliss. It's my pleasure to welcome you back here to our series on government information gathering. This is officially going to be the final webinar in our series. And the reason I say officially is because if you recall from the last webinar, webinar number 5, it was my intention to cover the entire topic of international evidence gathering in one single session. Unfortunately, that proved to be way too ambitious. As you see here, we did work our way through a number of the various methods for obtaining foreign evidence. We stopped short, however, on the mechanics of how information gets exchanged, and that was within the topic of FATCA. Became clear to me that it was a little too ambitious to expect that I'd have been able to cover all 5 of these topics with the level of detail that I wanted to in less than an hour. And we had already crossed over the 60-minute mark before even touching on the topic of the mechanics of information exchange. So we're going to pick up where we left off, and that is on the mechanics of information exchange. There are 2 main methods that information gets exchanged between foreign banks and the IRS, or between foreign governments and the IRS. There's the Model 1 Treaty and the Model 2 Treaty. Now, as I was preparing the slides for this presentation, I was trying to think about what the best way for presenting this information would be. I thought about a few different things. Number 1, I thought that I could lay out a simple rule and a procedure for how each model operates. But then as I was thinking about that, I felt that it would simply be too vague and ambiguous, and it would just be more confusing for you if I presented it that way. So my next thought was to present it as a case study where we actually talk about a real live agreement between the U.S. and another country. And so I thought that that method was probably the best way to illustrate this whole concept of information exchange. And what better country to start with than Switzerland? As many of you know, the U.S. And Switzerland have a Model 2 agreement in effect. And I wanted to start out with a case study on Model 2, because Model 2, the mechanics of Model 2 are harder to grasp and wrap your head around than the mechanics of Model 1. And so that's why the inspiration was to do a case study that was specifically tailored to Model 2. And after we go through the nuances of the US-Swiss Model 2 agreement, it is going to make understanding Model 1 so much easier. So I have to caution you in advance that we are going to cover some complicated concepts that are full of nuances. And that is, again, specific to the US-Swiss model. But at the end of the day, it's going to make understanding both of these models exponentially easier than if I were to just give you a vague definition of each and then move on to another topic. Now, the one disclaimer that I want to give you up front is that the Swiss recently announced that they would be, or that they are going to be transitioning to a Model 1 agreement in the not too distant future. So just keep that in the back of your mind. The other point that I'd like to make before we dive into Model 2 is that oftentimes the best way to understand a concept is by comparing it to another concept. Then you understand the fine distinctions of each. And that's what I've attempted to do here. So without further ado, let's jump into the Model 2. What the heck is a Model 2 agreement? Well, under a Model 2 agreement, the Swiss government authorizes Swiss financial institutions to report U.S. account information directly to the IRS. And they authorize their banks to report this information directly to the IRS without the threat of prosecution. Recall from the last webinar that Swiss bank secrecy laws prevent or make it make it illegal for a Swiss bank or for bankers in a Swiss bank to exchange the information of their clients, their account holders, with a foreign government. So the bank secrecy laws that are on the books in Switzerland outright prevent a Swiss bank or a Swiss banker to exchange a U.S. account holder's information with the IRS. So it became clear as the Swiss government and the U.S. government were drafting the terms of this model agreement that some type of exemption was going to have to be carved out for the banks and for the bankers to be able to exchange this information. Otherwise, no banker was going to take the risk of exchanging information to exchanging information to the IRS. The threat of prosecution was simply too overwhelming, and they were not willing to take that risk. So what the Swiss government did is they carved this exemption into the Model 2 agreement, where they guaranteed the banks immunity from prosecution at the hands of the Swiss government. Now, the foreign financial institution, here the Swiss banks, they have to provide the IRS with nameless aggregates. No questions asked. What the heck is a nameless aggregate? It's nothing more than the quantity and type of accounts that the Swiss bank holds belonging to U.S. account holders. Okay, so let's say, for example, that Swiss bank ABC has 200 U.S. account holders. As part of a nameless aggregate submission, the bank would have to tell the IRS that it has 200 U.S. account holders. But that's not all. The bank would also have to indicate what type of accounts belong to those U.S. account holders. For example, are they savings accounts? Are they run-of-the-mill checking accounts? Are they investment accounts? That is what's meant by the nameless aggregate. The quantity and type of accounts held by the Swiss bank belonging to U.S. account holders. Now, after the bank provides the IRS with these nameless aggregates, step 2 is for the bank to identify all U.S. account holders whose account information is contained within the aggregate information. In other words, out of those 200 accounts that the Swiss bank identified as belonging to U.S. account holders, the bank now has to identify the names and the identities of the account holders of each one of these U.S. accounts. The bank must then notify those respective account holders and obtain their consent before disclosing their complete information to the IRS. So all this is saying here is that in step 2, the Swiss banks have to dig deep, and they have to find out the names and identities of the clients who hold these U.S. accounts. It must then notify these account holders that their specific information will be turned over to the IRS. And finally, it must obtain their consent. So at this stage, all that's being requested is consent by the is consent on the part of the U.S. account holder. Now, what is meant by complete information here? It includes taxpayer identification number, taxpayer's name, address, and date of birth. The notice that I've referred to here, when I say that the Swiss bank has to notify the respective account holders, this notice is oftentimes called a declaration of consent. And in that declaration of consent, the Swiss bank lists the parade of horribles that a U.S. account holder can expect to face if he doesn't consent. One such horrible is that the bank may terminate its relationship with the account holder. Now, as you can imagine, there will be those who consent and there will be those who do not consent. Those account holders who refuse to consent are referred to by the IRS as recalcitrant. The Swiss bank will, however, provide the IRS with complete information on each of the account holders who consent. So that's a non-issue. Those who consent will have their complete information exchanged by the Swiss bank directly to the IRS. Those who withhold their consent will be fighting an uphill battle in the event that the IRS makes what's called a group request. What is a group request? It's a demand for complete information on all recalcitrant account holders. Upon receipt of a demand, and by the way, this group request is submitted by the IRS to the bank. When the bank receives this demand, this group request, it must provide complete information on all recalcitrant account holders, not to the IRS, but to its foreign government for exchange with the IRS. So this is a very fine distinction. Again, when the bank receives a group request, it must provide complete information on all recalcitrant account holders to its foreign government for exchange with the IRS. The foreign government is expected to exchange this information with the IRS within 6 months. However, the account holder has the right to challenge the group request in Swiss court. However, the account holder is unlikely to prevail as the odds are stacked against him. Now that we have some background on Model 2, let's talk a little bit about Model 1. Under a Model 1, the foreign bank must report information directly to its respective government about its U.S. account holders. The government, in turn, automatically exchanges this information with the tax authority in the relevant partner country. So, under Model 1, as we know, the Swiss government will soon be transitioning to that model. Once it officially does, what will happen is that a Swiss bank will essentially exchange all of the information pertaining to its U.S. account holders to the Swiss government or the Swiss taxing authority. The Swiss government, in turn, will automatically take that information and ship it over to the IRS. No questions asked. It's an automatic exchange from one government, the Swiss government, to another government, the U.S. government. And this exchange usually occurs once per year pursuant to an income tax treaty or exchange of information agreement. What are the primary differences between Model 1 and Model 2? Well, under Model 1, the foreign government, and this is just restating the obvious, so don't get nervous here. Under Model 1, a foreign government serves as an intermediary to the supply of information from the foreign bank to the United States. Under Model 2, the foreign financial institutions report directly to the IRS. Now, you might say to yourself, well, wait a second, I thought you told me that if a group request was issued to a Swiss bank for the names of recalcitrant taxpayers, that the Swiss bank would then pass that information on to the Swiss taxing authority. And the Swiss taxing authority would then turn it over to the IRS. So what are you telling me now? That under Model 2, foreign financial institutions report directly to the IRS? How can that be so? Well, remember this, as I've already described. There will be a time that there will be instances where a Model 2 involves a foreign government directly. And that's in the scenario I just gave you, where the IRS makes a group information request. So while while the general rule for Model 2 is that the foreign financial institutions report directly to the IRS, there is an exception, and that exception is when the IRS makes a group information request. Then, and only then, is a foreign government, in this case a Swiss government, involved. And in what capacity is the Swiss government involved? Well, they become what we would call the transmitter of information, of specific U.S. account holder information to the IRS. The second difference is the requirement under Model 2 that foreign financial institutions first obtain the consent of U.S. account holders before reporting their specific account information to the IRS. Remember this, nothing short of a U.S. account holder's unbridled consent is required before a foreign bank can report this information to the IRS. All right, so again, I'm not trying to beat a dead horse here, but understand that under Model 2, the banks have to obtain consent from their U.S. account holders before they can provide specific account information about those account holders to the IRS. If the U.S. account holder withholds consent, then the banks cannot turn that information, the specific type of information that I'm referring to, over to the IRS. Distinguish that from the nameless aggregates. Nameless aggregates, the taxpayer does not get to withhold or refuse consent. Why? Because it's completely anonymous. All nameless aggregates are doing are accomplishing the goal of identifying for the IRS how many U.S. accounts are maintained at the foreign bank and what type of accounts they are. It doesn't go beyond that. It doesn't get into anything, any specific information relating to the taxpayer individually. Account holder consent is not required under Model 1, and that is a significant difference that we're talking about here. The reason why account holder consent is not required under Model 1 is because information is being exchanged automatically between the tax authorities of two countries. So what's the takeaway? At the end of the day, a group request provides the IRS with the same information that the foreign financial institution would have reported to the IRS had the account holder originally consented. The only difference is that it takes 2 steps now instead of just 1. And by 2 steps, what I'm referring to is not only the IRS group request, but also a potential hearing in Swiss tax court. At the end of the day, if the U.S. account holder continues to refuse or withhold their consent, then they can challenge the Swiss government. They can challenge the Swiss government's attempt to turn this information over to the IRS. Again, they are unlikely to prevail. So a Model 2 does indirectly what an automatic exchange under Model 1 does directly. And here you see what we've already discussed at the top of the webinar. The Swiss government will soon be transitioning to a Model 1 treaty within the next few years. And in that case, the Swiss government will be exchanging information directly to the IRS and the taxing authorities of other countries. Here's an interesting question to ponder. As more countries are pushed to the brink to share tax information through FATCA, the focus now will shift to America's willingness to reciprocate. And who can forget that expression, what's good for the goose is good for the gander? Is this hypocrisy? Well, at present, the U.S. does not provide foreign governments with the same detailed information about their residents who bank with U.S. banks that it requires foreign financial institutions to provide about U.S. citizens who bank with foreign banks. So at some level, there is hypocrisy going on here. The U.S. government is essentially asking foreign governments to do something that it hasn't, or that it's not willing to do. Here's an added bonus that I have for you. This deals with a special problem, a hypothetical that was specifically designed to test, for you to test your problem-solving skills and your understanding of these rules as they relate to international evidence gathering, to a set of facts. And as many of you know, my motto here is learning by doing. Um, Unquestionably, reading and studying a topic will help you understand it. But unless you actually do something, unless you actually walk through a tax problem to see if you can identify the issues and apply these rules to a set of arbitrary facts, will you know how well you truly understand the application of these rules. And this is truly where the rubber meets the road. So this is where the hypothetical lives. And I apologize for the lengthy URL. I wish there was a way to just give you a quick link, but I am planning on making these slides available to you independently of the webinar, so that you have the opportunity to go through them, digest them at your own pace, and then take stock of all of the links that you see here, because there are some additional ones coming up. Here are some other helpful resources. Again, most of these are articles and blogs that exist on my tax blog, which is called Tax Chat. And again, I will make these slides available to you. As many of you know, I've recently launched a podcast, and we are now up on iTunes. The goal is to try and record at least one podcast every 2 weeks. It might be a little ambitious. Only one is up right now, but there are certainly a number of issues to talk about, and no lack of content. So if you have any suggestions for tax podcasts, let me know. I have a few of my own that I've been thinking about, and that I think would encourage a lot of good robust discussions, especially in the area of the IRS's voluntary disclosure program and Streamlined. Finally, this is my new ebook. I've recently published an ebook on foreign asset reporting, navigating the choppy financial seas. And there's a very special giveaway here for the first 20 to respond. If you are among the first 20 to respond, you will get a free copy. I encourage you to go to my Facebook page at facebook.com/taxwarrior. In the left-hand corner, there's an app that you can click on. It says welcome, and you'll be able to sign up for the free ebook. And again, if you're one of the first 20, you will get a copy for free. Finally, if you have any questions about anything that we've covered in this webinar, and not just this one specifically, but any of the other modules going back to the very first one, please feel free to reach out for me. I love to hear from readers, and from readers of my blog, and from viewers of webinars. Don't think that in any way, shape, or form you're disrupting me. I love this. I love this engagement that we have through social media. So you can call me, you can email me at mjdebliss@deblisslaw.com, or you can go to my website and take a look at some of the blogs that are up there. And I look forward to hearing from all of you, and there will definitely be some future webinars covering other issues that relate to many of the topics that we've talked about, and that relate to other topics outside of government information gathering. So stay tuned for what is to come. Thank you for taking the time to listen to these to these presentations and these webinars. It took a lot of time to prepare them, and I hope that you got a lot of value out of them.